Hello, welcome. I'm Roger Royce, host of the 10,000 Startups podcast, where every week we bring you a new podcast interview with a subject matter expert on an area of law relevant to startup companies. And this week, we've got one that, as we were talking earlier, really doesn't get enough attention, and it really ought to. It's piercing the corporate veil. And our guest here today is Tracy Duplantier. I think I got that right.
You did. Good job.
She's coming to us from Louisiana. Are you in New Orleans, by the way?
I am.
Oh,
Yes.
well, like bon temps relay then. Coming to
That's
us
right.
from Louisiana to talk to us about piercing the corporate veil. Tracy is a practice area specialist with Lexis Nexis. She's been there 16 years, and she has a lot of really good information. So just to set the stage on this before we get started, and I talk about this in my book quite a bit. I've formed thousands of companies now, and you might, every once in a while, people just assume they have to form a corporation or an LLC, and every once in a while they ask me why, and I tell them, well, there's three reasons. One, of course, is we need a vehicle to divide up the equity among the members. We need a vehicle to start establishing your ownership rights in the intellectual property and the contracts and the goodwill that you're building. But the third one is the most important. We need something to protect you from liability. And in my world, startup land, startups typically fail the first 2, 3, 4 times out before you hit on that big one. In fact, I've got one client, he had 29 ideas that failed, and the third one became a $1 billion company. The 30th one became a $1 billion company. Now, just imagine if on that first failure it would have bankrupted him. He never would have gotten to the later one that became a success. So our goal here today is to give you the tools so that you end up, if things don't work out well, that you walk away unscathed as the founder and you live to fight another day. And with that, Tracy, welcome to the show. Thanks for being here. This is a really important topic, and I'm glad you're here.
Well, thank you so much for having me. And, Roger, I think that you're right on with thinking that this is sometimes not getting enough attention. The importance of really setting yourself up correctly at the beginning and following along with those formalities throughout the time that you have that business is very important for limiting that liability and showing the courts that you are actually a separate entity. And so to keep us kind of on point, because I definitely have a lot to say about this topic, I did go ahead and prepare some slides. So I'm just going to go ahead and share those so that we have them for the benefit of keeping us moving forward. And you've already kind of covered the reason behind having a corporate form, right? To be able to take advantage of tax consequences and things of that nature. But more specifically, as we're talking about today, to be able to shield the owners from that liability that might come. And of course, we don't want to shield the owner from liabilities they should have, because when we purchase something from a supplier or hold ourselves out as a business, we want to have that set up correctly and we want to do the right things. But in situations where it wasn't actually the company's fault, and we want to make sure that we have that protection. And so piercing the corporate veil, as we have this kind of funny little clip art here, we want to think about this as a concept as we're setting up, as we're continuing operations. You need to know that it's out there because you really want to be able to protect yourself from having to deal with these types of claims. And in thinking about that, you want to think like a litigator. You want to think about how someone else might develop a story around what you tried to do as an owner, and did you try to shield yourself from things that you should have been responsible for? And I'm sure we'll get into some of the different topics on that as we go. But know that this is more of an extreme it doesn't happen a lot, but there are a lot of cases about it. Because people, even though courts will be hesitant to pierce, that it definitely gets litigated quite a bit. And so you want to be able to have your facts, favorable for you so that you can get out of court with this type of claim as soon as possible.
Yeah, let's pause on that for a second,
sure.
Because that's my experience too. Doesn't happen often, but it gets threatened all the time.
Absolutely.
And in my view, on the corporate side, is that if, of course, anybody can file any claim over anything, but if you end up in court, then in a way, I failed. I haven't done my job. I want to set the stage so much that any reasonable lawyer will look at it and say, there's no way we can win. Let's not even try. So even though you might be good because you formed that corporation on your online incorporation tool, you really want to dress the baby. And sometimes the baby's really ugly, so you have to do a lot of dressing. So let's talk about that.
Absolutely. And, so just to be clear, there is a general rule that shareholders are not liable for corporate obligations, but this piercing the corporate veil is a balancing test of allowing that shareholder kind of limited liability, but also making sure that those injustices don't get hidden by the corporate form. And so when we're talking about kind of dressing the baby, it's important not to just set up properly and then forget. You want to also employ all of those best practices as you continue the ongoings of the business. And so we'll talk about some of those best practices. I know I have a long list on a slide for you. But as we're looking across the country and how this issue gets handled, in case you are not incorporating in Delaware or California, which are the two states I'd like to talk about today, it is really important that you know that this is a very jurisdictionally heavy issue. So every state has a different nuance in how they deal with these things. We do see that states have different tests that they try to go back to, but I'll show you later on, the application of the tests is really hard because it is very fact intensive. And so that's one thing that we hear over and over again, is that the opinions can be very, very thick. Maybe they take a long time to talk about piercing and then ultimately decide not to pierce at the end. It's almost like the opinions act like warnings, so that we're trying to learn how to actually conduct business well, and kind of take advice from some of those folks that were maybe not as lucky to avoid court. So
let's walk through this a little bit. This list here, sorry to interrupt, but this list here of yours is really good because it really outlines the ways that founders can get stuck. So I guess the number one is this contract versus tort issue, and I tell people, be careful what you sign. You've probably guaranteed your lease without knowing it. You definitely signed on to your credit cards, stuff like that. So that's one where you just assume that liability and you can protect yourself by reading your documents. But the tort one's a little bit different. How does that work?
Absolutely. So, sometimes we find with tort that a creditor might be thrust into a relationship with a company. Let's say, for instance, that you own a taxi cab company and someone is injured. That company is going to get sued. And if the company is not adequately capitalized, or if that creditor or injured plaintiff is trying to recover more than the amount of insurance that you have, they may try to pierce the corporate veil to recover from you. And so being in that tort relationship is a little different than the contract because we didn't know that injury was going to happen. And so the creditor or the plaintiff didn't have the opportunity to seek those guarantees in the same way that something under contract had the opportunity to ask for a personal guarantee. So we see courts kind of dealing with those issues a little bit differently. Again, remember, courts are trying to balance that injustice that's happening. And so the relationship of the parties is really an important piece of all of this. So great question.
Thank you. Can I ask about the next one? When we have a bunch of affiliates all over, subsidiaries, brother, sister corporations, what's going on there? Why does that increase our risk?
Yeah, so this is a really interesting concept. And that can even happen like with the example that I just gave with the cab companies. Many times there are tax, breaks or incentives for having businesses structured in a certain way. We'll also see that, maybe a type of business or industry is a little bit more, risky. So we might have a situation, here's an example, a distillery would be able to sell liquor, but maybe a particular company that makes the liquor would not be able to be involved in sales. And so there's different kind of structures that you can utilize multiple businesses for, and those businesses would need to be set up separately so that we don't get into this single business enterprise issue. Just as an example of the taxi cab, there's a really, kind of well-known case out of New York where there were 10 different cab companies that each only owned one cab. and they had the minimum amount of insurance that was required by the statute. So they were doing what the statute required them to do. But when the plaintiff was injured, he wanted to recover more than the $10,000 of liability insurance. And so he tried to say all the cabs were together as one single business enterprise. And in that case, the court decided not to allow that. But we have seen a lot of different cases, and there was one that just came out of Pittsburgh, out of Philadelphia, that talked about how we could pierce a sister corporation with the same owners, maybe even utilizing the same actual physical business. Again, they're looking for that close tie where the company's relationships to one another almost act as one enterprise. And again, different jurisdictions have handled this differently, but we need to be aware of how our jurisdictions handle it. And if there is that maybe potential that one company might be responsible for the debts of another because of that close relationship. And again, that's why it's so important to keep, very extreme corporate differences.
Right. Well, we're going to talk about how to protect from that happening in a minute, but let me go down the list. This other one is really interesting, reverse veil piercing, which I assume is that the shareholder has a debt, is trying to keep the creditor from getting after the assets by putting them in an entity. And I recall a few years ago, there was a case, there's a Colorado bankruptcy court where they just disregarded, I think it was an LLC, and said, yes, shareholder of the owner, you can go after the assets of that entity to satisfy your debt. Does that happen often?
It really depends on the jurisdiction. I'll give you the lawyer answer. It depends, right? But you will see even some family law cases where it's a husband and a wife that are married, and the husband has all his assets in his business, which he is not really holding on to as a separate business, but it's very commingled. That courts have actually allowed a wife to recover from the assets of the business because of the obligations of the husband in a divorce case. And so there's some really interesting, cases out there but they are very fact heavy. And so I think that's the important piece of that. And I'll just jump ahead to the statutory provisions because I'm interested in that one. In Delaware, for instance, they have the shareholders are jointly and severally liable for declarations and payments of dividends. And so it's important to understand if there are jurisdictional statutes that are also going to force you into a liability situation, even if you've tried to remove the liability by having that proper corporate form.
Yeah, and we're going to talk more about California in a little bit here, but we really have to watch that because it comes up in places you might not expect, especially for employee wages.
I was going to say that, yes,
strong
absolutely.
Public policy in protecting employees, and of course, just the fraudulent conveyance stuff. Okay, great. Delaware. Almost 99% of the companies I incorporate are in Delaware, so that was going to be my question. How tough is Delaware on this issue?
So Delaware hosts a whole other level of extremely limited circumstances. They have a lot of great commentary about piercing the corporate veil, but they really have restricted themselves from utilizing that particular equitable remedy. In many cases, they will reach for even other ways that might not have been discussed to be able to right injustices. Delaware, because they are, arguably one of the most sophisticated business courts in the country, they really do try to make sure that the businesses are protected, that we're holding this, this separate form of a business to a very high paramount. However, they will pierce the corporate veil if there is some illegality or fraud, especially. We're talking about injustices here. So just like any other jurisdiction, they are going to kind of weigh that information. They also don't just pick one theme of the type of piercing the corporate veil. That they use instrumentality, alter ego. They use a lot of different verbiage. And so again, they've been able to kind of utilize those different features in ways that it's most beneficial for all the parties involved.
Okay. Yeah, so fraud is a big word, and it means, I think, different things in different contexts. And in the case of veil piercing, I know you're going to give us some examples, but maybe talk a little bit about what that is. That sounds very fuzzy to me. Fraud or injustice.
Yes, and so, a lot of these cases are just these beautiful sentiments of what we want justice to be. And that is one of the reasons why this issue or this area is so confusing. And when we think about fraud in this sense, it is not a fraud that needs to be pled with particularity. We're really looking at just what is equitable or what is unequitable. And so it can be any situation where someone is trying to take advantage of another or take advantage of a situation, which should not be allowed. And, an example here just also is on the screen where a parent is trying to shield their responsibility for their debt by leveraging the company, which then they might just throw out, right? And then start a new company. And I do have a case example of that one we'll go through that actually happened in California in just a little bit. I wanted to just give you a couple of more facts about Delaware before we move there. Delaware does have particular facts that come up over and over again that they look at. And of course, all the factors are going to be important and none are dominant. So a very, well-rounded looking at the facts. However, we really do need to follow the money in a lot of these situations because the money can clearly tie the owner back to the company in one way that shows that commingling that we don't want, that would erode that protection. And so having the company be adequately capitalized at the outset is a really important feature that we see that it was set up with intention, and then continuing the solvency.
Can I stop you on that one?
Yeah.
Adequately capitalized. So let's just make sure people understand what that means. Let's suppose we're forming a company and we're about to go in a very high risk business that's going to incur a lot of obligations, a lot of debt. And I know that's a factor, and courts have talked about it. They say, look, you put no money into this corporation. You used it only as a shield from liability. There was never a chance you were going to be able to pay for what you were proposing to do. That to me is kind of the stereotypical case, right?
Yes,
Oh,
absolutely.
there you go.
And
We got a slide.
I have a slide here for what is adequate capitalization because this comes up so much. And capitalization at the very least needs to be to satisfy all the corporation's liabilities and to conduct business. And that can even be a really broad, kind of sweep of what that is. But I think that what we're really trying to shoot for here is that we didn't take on a liability or do business with a vendor that we knew we wouldn't be able to pay back. So being able to show that we can at least get this moving and get it off the ground and continue it in an ongoing basis. And that undercapitalization, to kind of look at the juxtaposition of those, no capitalization, no initial capitalization, when it is just a shell, that is definitely going to be a situation where the courts are going to be more likely to lean on piercing than if you have some money within the business. This
is important because almost always when we set up these companies, we start with very little money. We start with a par value, we sell stock at 0.0001 cent a share. And keep in mind, that's just to get you formed. That doesn't mean, you ought to be raising enough money to do what you want to do fairly immediately. And that brings me to the second one, whether the company was solvent. Pretty much every startup company is insolvent at the start. So this is one we got to be careful about, right?
Absolutely. And I think that following those corporate formalities, which we'll kind of go through, but having separate bank accounts, keeping at least minutes, having regular meetings of shareholders, even using different letterhead, whatever it is you can do to really set that company apart from the owners or even other sister companies is going to be important to again support the notion that, okay, we're a startup. That might be more of an understandable thing for a court. And so adequate capitalization alone is not enough. We can have all these other facts on our side. And so you want to control what you can control. And so I think that's the point of don't just incorporate and then move on. Make sure that you are setting up the best set of facts, telling the best story in how you held yourself out and what you did as a separate company. Yeah. And then keep in mind too, because everyone is probably undercapitalized, not everyone, but a large amount, right? There has to be an element of fraud or some type of injustice So just because you're undercapitalized doesn't mean somebody's going to be able to pierce. There has to be some compelling reason why the courts would erode or, displace that corporate form.
Yeah. So going back to the dressing the baby concept,
Yes.
that third one is the one I get a lot of pushback on, the corporate formalities, because businessmen typically they view some of this stuff as kind of silly. Like, why do we have to have this in writing? Why do you have to have minutes? Why do they have to have these recitals and all this stuff? Well, that's a factor, right?
Yep.
And the more you can comply with corporate formalities like your General Motors, the better your odds
Absolutely.
are, right?
Yeah, and I think a lot of people think that they're just kind of, they are, of course we would do this. They're kind of like no-brainers. But it really is important to think through some of the factors that we can look at in case law. And here's just a slide of different California court factors that they've looked at. Commingling of funds. It's easy enough to have a separate bank account. Don't put the corporation's money in your account. Having the ability to have the individual assets of the corporation only used by that corporation. Don't take the company car out on weekends and things like that. So there's a lot here that we've seen that the courts have looked at that might just seem a bit silly because they are no-brainers. But a lot of times in the haste of trying to get something off the ground, or even in just regular life, we forget about these best practices. And so it's a really good thing to keep them in mind. And so that's why I wanted to provide them in writing, and we're going to talk through those a little bit.
The commingling one is probably one of the most important ones, isn't it?
It is weighted heavily.
I recall years ago I had a client that did not understand this issue very well, and I remember going through the board minutes, and we come across things like, because he knew about the formality part, but then there were things like, approve, the purchase of a sailboat for the founder and stuff like that. And it's like, hold on here. Your investor's going to freak out when they see this.
Yes, absolutely. It does not pass the smell test. And even having like corporate assets. I'll kind of go through, there was a case where it's the Blimpie case, and Blimpie created a company just to own and manage leases, which were really liabilities and not assets. And so the court looked at it and like, this doesn't have even assets, it just has liabilities. And so if you are setting up, maybe several companies that are going to relate to one another, maybe there's tax benefits for having more than one corporation or more than one entity, keep in mind that you really have to have some consideration as to why one company would have certain assets over another. And you want to make sure that you're balancing those companies in the amount of liabilities you're giving them and assets. So you want to avoid the presumption that it is just a shell. And so that having its own unique identity, its own legal identity, it's of course going to have something it can offer. And so that's a big piece of that.
Okay, so I'm in California, in Silicon
Yep.
Valley. So even though I incorporate these companies in Delaware, they do business here. So they're going to attract some California law, even if they don't want it. So let's talk a little bit about, what it takes in California, which is generally viewed as somewhat of an activist state. So the rules here are oftentimes a little different than in other places, and sometimes surprising.
They are. And the California overall, I want to leave with you the impression that the relationship between the type of company, the owners, the creditors, or the parties that they are holding themselves out to, those relationships really make a difference in California, even more so than in other jurisdictions. When we are looking at California, they use a piercing language or a piercing theme that they call the alter ego doctrine. And I think the best way to think about this is like Peter Parker, who is Spider-Man, that, lack of separate identity of Spider-Man and Peter Parker, we're really looking for where they're so much integrated into one another that we can't tell where one begins and the other ends. And with alter ego, you can kind of see the picture on the slide here. If we think about just being able to take off a costume and then we're somebody else, that is really what the courts are looking for. So an integration or a lack of separate identities, so much so that the corporation is just being used as a tool. It's being kind of leveraged to do injustices. And that really is that second prong. There's a two-prong test. We want that unity of interest, and we'll look at some of the best practices around unity of interest. That is where we get into the conversation about capitalization or commingling of funds, having that board, having those board meetings, and having all of that memorialized. And then we look at also that requirement for an inequitable result if the veil is not pierced. And so when we're thinking about California, you really want to observe corporate formalities. Again, no one characteristic is dispositive because the court does look at all circumstances, but definitely consider that capitalization component. So that's.
So do you have some examples of where this has gone bad on people?
Yeah, so there's this really interesting case, this Talbot versus Fresno Pacific case, just to give us an example of how this has worked out. And even in that court, in the opinion, they actually say the law as to whether courts will pierce the veil is easy to state, but difficult to apply. And so, courts really acknowledge that this is hard. And that's why you want to make it easier for them by setting yourself up correctly. In this instance, we have a sole owner, Dorothy Lee, who owned a lumber sales company. And she purchased lumber from our plaintiff here, and then later on decided that there were some tax consequences and reasons for her to kind of restructure her business. And so she divided her business into two companies, and one of them took over all of the lumber accounts, the accounts receivable, the payables from the former business, basically assumed all of the liabilities. And that was the Fresno Pacific Corporation, which continued to do business as Sequoia Lumber Sales. But who got the assets was Sequoia Enterprises, and they got all of the business, the land, they got everything that they needed to continue to be solvent, whereas Fresno Pacific Corporation didn't have any of that solvency or any of those assets. And the court noted that when those kind of distributions were made, there wasn't a lot of explanation as to the consideration that the owner made. They also noted that corporate formalities were followed, but they were hollow. The same officers and directors were on both boards. Some of those officers and directors never showed up to meetings. While minutes were kept, it was clear that the main owner was the one signing off on all purchases and things from both companies. And then even at the end of the situation, we see that Fresno Pacific, who is insolvent, had a fire sale of all the remaining inventory, and the cash from that sale went into the owner's bank account, not into the company's bank account for later distribution to creditors. And so, this is a situation where it's really easy for the court to, again, follow the money, to track, how did this happen? Where did the liabilities go? Where did the assets go? What was kind of the efforts in keeping a separate company and owner, dynamic. And so the court eventually found that the transfers and conveyances were made with the deliberate intent to hinder or delay or even defraud the creditors from collecting on the amount of money from the purchase of the original lumber, and that the two companies were really acting through their president, that stole stockholder, not speak. But again, this is another, brings up another point of making sure that when you are incorporating or when you're thinking about your board, that you maybe think about having different players on each one of those different boards if you're going to have more than one corporation that you're running at the same time.
Yeah, that's a good point. And this is a California case too. I can tell by the names of the companies, Sequoia, Fresno, but that transaction that's described there, very common, very common. We do this all the time. We do spinoffs for tax efficiency and also for business, fit and focus. And
absolutely.
Yeah,
and jurisdictional concerns as well.
That too. And rarely, do we have a lot, certainly never do we have cash consideration moving around. So we want to make sure, and in my reorganization documents, I'll recite all the reasons we're doing it, and there will be a specific recital about solvency and good business intention.
Yes,
okay.
and when we're thinking about what's the main takeaway, we want to make sure that we're observing those corporate formalities. And I know we're really driving that part home. But handling of funds, even throughout the time that you're operating, making sure you're keeping those funds separate. When we're thinking about governance, that we're keeping track of all those documents. You really want to show that existence of that separate company. That's really the main concept here. And again, think like a litigator. If someone was going to bring you into court, what would they say that was bad? What injustice were you trying to do? How might you have been trying to defraud? Or is there a good story that you can tell and how you're really trying to hold yourself out as a company that was stood up properly? These are just some best practices to avoid veil piercing, and they fall in line with, the considerations we see in the cases. When we have a separate entity, the observance of corporate formalities is always the very first one that's listed in these types of lists. And there are quite a few here that, we've already kind of talked through those annual meetings of shareholders, making sure you have a bylaws or operating document following that. You've talked a little bit about stock and issuances of stock. You want to keep that stuff in writing. You really want to keep track of where all of the company allocations have been made and where are those corporate documents. And there's a whole separate conversation you can have about, should that be in print? Should it be in writing? It's in a physical form, or is there a really good place we can keep this in electronic documents? So the storage of those documents, being able to get to it quickly if it's needed. So all of that kind of stuff is really important. The last one here on the page, the separate letterhead, business cards, separate signage. Again, you don't want your business to be mistaken for something else, a different business, or even for your own maybe solo adventures that you might be doing that are not part of that startup. Gotcha. So those are just some. And then, of course, they continue, right? Because there's a lot here that people will tend to get themselves into trouble with. Again, you're going to see a lot of commingling, sharing of employees. It's really important that we show that there are a lot of thoughtfulness happening. So again, for those single member LLCs, you want to avoid the only member or the member being the only person that's performing work for the company, because it really does blur those lines. And just like we were talking about that control piece, it makes it a lot easier for a court to say, this person had sole control. And so in thinking about how you're going to structure your boards or structure responsibilities and ability to make decisions, I think that's an important piece to think about as well.
Yeah, absolutely. The single member sounds risky, and those are the reverse veil piercing cases are a lot easier in those. So we got to be super careful. Well, I really want to thank you for being here, Tracy. Now, you've got these slides. I'm going to go ahead and put a link to these in the show notes so people will be able to download them, and probably some other materials. Is there anything else that we'll be making available to folks that want to, because there's a lot of words on these slides, and
yes,
we get through all of them. If people want to look more into this, what other materials do we have?
Yeah, so absolutely. And this last slide here is on other key legal considerations for startups. Until this slide, basically, we've been talking through piercing the corporate veil. And so we have some materials. If you are in California and you want to read about that a little more, we've included in the show notes and the follow-up notes that you can take a look at. Veil piercing specifically in California and some of those best practices for avoiding that. But we're also going to include this other key legal considerations for startups checklist. This is going to further flush out other things that you might want to consider. That select an appropriate legal structure for the startup includes the conversation about piercing the corporate veil, because you want to be set up correctly. But there's a lot of other considerations that I'm sure, in a lot of your other podcasts you're going to cover. But trade secrets are on here too. I know that was a podcast that you've just had recently. But there are a lot of considerations here. And so we wanted to make sure to give you guys just a list that you could take a look at. And so, and then there's two other materials specifically for startups that are also going to be there. And so you'll be able to click on the link to get there.
Okay, great. All right. Well, once again, thank you, Tracy Duplantier from Lexis Nexis, Practice Area Specialist.
Thank you so much for having me.